Good afternoon. Welcome to Broadband Breakfast Live Online for Wednesday, October 16th, 2024. My name is Drew Clark. I'm the CEO and publisher of Broadband Breakfast. Happy to welcome you all to another edition of our weekly webcast. We focus on better broadband, better lives at Broadband Breakfast. That to us means the infrastructure that enables high capacity broadband, and also the knowledge, the wherewithal, the tools to make use of those that better broadband connectivity. And so we are a news and events community. We do reporting, fact-based reporting every day on America's broadband build out, and we are the community for high capacity internet and the policy discussions around it, whether that's the BEAD, the Broadband Equity Access and Deployment Program, or controversies around wireless topics and spectrum, or the Universal Service Fund and its impact on the Affordable Connectivity Program, or net neutrality and controversies around that. And speaking of which, I've just laid out the agenda for a conference that we've just announced moments ago, Broadband in the Next Administration. This day-long conference will be on Thursday, December 12th. We've just, again, posted this on Broadband Breakfast. We'll be sending more out about this later. Like we do pretty much every three or 4 months, we do an in-person event. This one will be downtown DC. We're excited to talk about what will happen in the role of broadband in the next administration, whether it's Kamala Harris or Donald Trump. We'll be considering those issues and those questions on those four topics and more, but at least those 4 topics: BEAD, spectrum, Universal Service Fund, and net neutrality and other similar issues. So you can register now. Early bird rate of $145 will go up to $195 a day after Election Day. And as always, members of the Broadband Breakfast Club can take $100 off of that price as well. Broadband Breakfast Club members have unlimited access to all the content on Broadband Breakfast. We do hundreds of stories a month, and you can get a certain number of those by joining and being a free member of the Broadband Breakfast community. But we encourage you to sign up for the Broadband Breakfast Club. It's only $99 a month, or but if you buy for a year, it's $590, or actually $490 because you're here and in the Broadband Breakfast community. Well, I do want to say one more quick thing. We're going to hear next week on the topic of BEAD and satellite broadband. So I hope you'll join us on our free programming, because we do this weekly webcast every Wednesday at 12 noon Eastern Time, and it's made possible by the support of sponsors, including Utopia Fiber, Comcast, Ookla, Wesco, Coos Systems, the Institute for Local Self-Reliance's Community Broadband Networks Initiative, the California Emerging Technology Fund, G-Fiber, Broadband Now, CostQuest, ACA Connects, new sponsor. Thank you, ACA Connects, for joining. WISPA, Broadband Without Boundaries, and NCTA, the Internet and Television Association. So thank you for your support, whether you are a sponsor or whether you're a member of the Broadband Breakfast Club. We thank you. That enables us to do the journalism and to help build the community around better broadband, better lives. I'm going to go ahead and change the view here for those of our panelists who have their video cameras on. We have one more panelist who we're going to welcome on. Whether we can get her on video or not, it remains to be seen. But let me just sketch out a little bit about this topic, because we are very excited to have this discussion. And although I did get super familiar with Title VI of the Telecom Act years ago, I've probably forgotten half of what I once knew, and I do want to just point out that at Broadband Breakfast, we focus on the broadband capacity, right? But we can't ignore the fact that we got here because we had technologies from twisted pair to coaxial cable to wireless transmissions. And each of these prior technological innovations in turn prompted a legal view of the world, right? And so the Telecom Act had titles around telecommunication services and around wireless services and around cable services. And of course, everything can travel over internet protocol, over the IP transmission system that is the basis for broadband communications. But yet we still have these different regulatory regimes, and we still have different products like traditional cable video services, right? And what we're going to talk today in this session is kind of where the boundaries on the services maybe don't necessarily neatly overlap, right? And so again, our specific topic today is cities and taxes on video and broadband. And we want to have obviously we get a diversity of views for almost all of our Broadband Breakfast Live Onlines. We don't necessarily get every single diversity of view that we'd like, but we certainly get a number. And we're super excited to have three experts on this topic. Cheryl Lianza, who's of counsel at Best and Krieger, a law firm that represents cities. Cheryl, in particular, has been practicing communications law for more than 25 years with a wide scope of practice, including internet access, broadcast and cable regulation, social media corporate accountability, and affordability in communications. And she's really been, the person to go to on many issues. She didn't put in her bio, but, the media ownership issue is one that I know Cheryl knows more than practically anyone on. So very excited to have Cheryl and with her knowledge of the intersection of civil rights and communications policy in our discussion. After Cheryl lays out her perspectives, we're going to hear from Bert Cohen, who is staff attorney and broadband policy coordinator for Connecticut's Office of Consumer Counsel. And he represents the interests of consumers in utility and telecommunications matters. And he also, before joining the Office of Consumer Counsel, was in private practice, primarily representing cable operators. So he's kind of seen both or all sides of the fence. And then our final speaker will be Jessica Ring Amundsen, or Jessie. She's the co-chair of the Appellate and Supreme Court practice for Jenner and Block, another law firm. And we can't ignore the fact that Jessie argued City of Eugene versus FCC, the very important case in the U.S. Court of Appeals for the Sixth Circuit on behalf of NCTA, the Internet and Television Association, regarding the franchise fee cap and the mixed use rule. And you're going to be hearing a lot more about the franchise fee cap and the mixed utility rule. But first, let me just go back and set the stage for what we're going to talk about here in another 60 seconds. And we're focusing in this discussion on how localities are pushing to put taxes or fees on streaming video and broadband services. Okay. And in part, there's no surprise here. The traditional linear delivery of video services is not, that's kind of your grandmother's cable TV, right? My kids' TV is, YouTube and TikTok and other kinds of streaming services or short form streaming services. But now there's all kinds of mixes from linear to short form, right? And so the central question we want to consider is how the burden is imposed upon the local rights of way as part of the physical connection to homes and businesses. And with municipalities contending that broadband and video streaming services are or should impact franchise fees, similar to those applied to cable providers, we're going to consider the appropriate compensation for the use of rights of way and what obstacles cities face in seeking changes or different fees from the traditional cable services fees. So let's dive in. Cheryl, I hope I haven't tilted the floor one way or the other. We want to hear what you have to say, and the floor is yours for 5 minutes.
Great. Good morning. Good afternoon, everybody. Great to see you. Thanks for having me, Drew. It's great to be here. I'm going to start, first of all, as Bert said, I'm Cheryl Leganza. I'm of counsel at Best Best and Krieger. And at Best Best and Krieger, I represent many local governments, including also in front of the Sixth Circuit, where Jesse and I were both arguing. But I'm not speaking on behalf of those clients today. I'm speaking for myself. And others may know that I also have a consulting practice, The Learned Hand. I still do both. There's a lot of opportunities here, but today I'm talking about my experience with local governments. And I also think as we go on in the conversation, we can kind of get a little bit more up to speed, I think, about some of the current debates and policy and law. But what I want to do today is start with kind of a few statements that I think are hopefully common sense and maybe a place where we can even all find agreement. I think we all know that we want companies that offer similar services to be treated similarly and fairly under the law. That's first. Also, communities need and benefit from, and everybody benefits from public infrastructure, whether that's roads or sidewalks or whatever. We need this infrastructure. The third one is private companies that use public property, they use the public's property to offer their product should compensate the public for that use. Fourth, changing marketplace behaviors do not mean that public needs, the needs for public infrastructure, go away. They still are here. And finally, local leaders are very attuned to the technology needs of their company, of their communities, of their constituents, and they strongly desire competition and the newest technologies possible, right? That they're anxious for technology to come into their communities, very much so. And frankly, many of these assumptions are enshrined in federal law. We have innumerable statements in the Communications Act protecting fair and reasonable right-of-way compensation, protecting local rights and responsibilities to manage the right-of-way. These local officials are responsible to the taxpayers and the voters of their communities, and it's their job to manage this public infrastructure. And local communities have always made agreements with providers to reside in the right of way. And we have some federal rules that have come in on top and put some boundaries around and some high priorities on different types of this agreement. But local communities have always been responsible for this kind of important issues. So what we have now, though, is a couple of things that have come into place. First of all, we have had the Federal Communications Commission interpreting some of the federal laws that apply here in ways that my clients, at least the many local communities, believe is really producing regulatory arbitrage, where now we don't have companies that are being treated fairly and equally. We have some companies who are contributing more than others, where we want to get to a place that everything is the same. And some of these FCC interpretations are really foisting a set of choices on local communities and local policymakers that they want to make for themselves. And it's undercutting community leaders that want to make sure that the public assets and the public needs of their communities are protected and well resourced. The current debate partially also comes from the fact that the original systems were set up, assuming that certain services comprise the lion's share of the marketplace. And now the marketplace is changing. And honestly, the debate, as Drew and Broadband Breakfast has framed it here, is really not that different from the same debate that we're seeing with regard to universal access to broadband right now. We have a situation where we have funding that is paid by some companies, but not others. We all recognize that everybody should be treated fairly. And we all recognize that access to this infrastructure is critically important. So how do we make a change given that the marketplace is changing and that now different services and products are benefiting from and earning profits off of very important infrastructure that may not be what was envisioned or what was the case back when some of these policies were made. And, for example, in the universal service context, right, we have like FCC Commissioner Brendan Carr saying big tech should help contribute to the universal service fund. So we have just this open-ended debate about what's the right way for us to fund infrastructure and to make sure that everybody's served in a changing marketplace. And we know that certain, sectors, every company, right, their responsibilities to the shareholders. So they're always going to say, well, no, we're not the ones to contribute. Somebody else should contribute, not me, the fellow behind the tree in terms of contributions. But that's not the right way to make public policy, right? We have democratic discourse, we have elections, we have policymakers to come up with something that's fair and even for everybody. So I think that's really where I want to start the conversation, is at that high level, and we can certainly get into a little bit more detail if folks want to get into some of those details. I'm happy to do that.
Great. Thank you very much, Cheryl, for spelling that that out the way you have. Let's turn right over to Bert Cohen to give your 5 minutes worth of thoughts on this particular question of streaming versus traditional cable and broadband. So go ahead.
Thank you, Drew. It's an honor to be here and with Cheryl and Jesse, and hopefully Jesse will get her technical issues resolved quickly, because we want to hear her perspective. It's important to note that my remarks reflect only my own views and opinions, and are not to be attributed to the state of Connecticut, nor to the Connecticut Office of Consumer Counsel, although I would hope they would support my views. But in any event, they're my personal perspective. As Drew indicated at the beginning, I have spent probably 3 decades of my professional career representing the interests of cable companies, and probably a quarter of that practice was involved in representing them on tax and regulatory fee issues, including litigating the issue of what is a franchise fee and what is an excessive franchise fee. I've also served on several working groups with the Connecticut Tax Department, known as the Department of Revenue Services, including one that specifically addressed cable and telecom personal property tax issues. So with that, let me give you a little bit of what at least my personal view is. Followers of Broadband Breakfast have heard much talk over the past few years about digital equity. From a consumer perspective, digital equity is quite important. But when you drill down to the various components of what that means, it also includes what I would call digital tax equity. Rather than tell you what digital tax equity means, I'll tell you what it doesn't mean. It does not exist when companies that are authorized to occupy public streets and highways to promote a myriad of like communication services are taxed differently based on which legacy antiquated silos they got their original authorization to operate in your jurisdiction. The current system of taxes and fees for providers is simply not sustainable, and we need to work together to come up with an equitable, sustainable, and competitively neutral tax structure for providers of all communication services. You guessed correctly if you said that those customers bearing the weight of the current taxes and fees are traditional cable consumers, a number of which are diminishing every quarter. Right now in Connecticut, we are under 40. We are down to probably what a base on a percentage basis, 40% of what the original cable subscribership market was. The consumers are not being affected. The consumers are not being affected, rather, are called cord cutters. The term cord cutting is just a true misnomer. It's the same wire attached to every pole or in every conduit in every premises that delivers these services. It takes no leap of faith or logic to realize that traditional cable consumers just are at a point in life where they don't want to use 3 or 4 remotes to locate their programming on the 3 to 10 separate apps that Drew earlier reflected about what his offspring are doing. They simply want to use one remote to point and click so they can watch Wheel of Fortune at 7:30 every night on the same channel without any effort. And yes, I am more than implying that those remaining customers of traditional cable tend to be older Americans or perhaps lower income folks who can't afford to subscribe and don't have the willingness to subscribe to 3 to 10 services to get their news, sports, and entertainment programming. So with that, the final piece that I'll say in the opening is we got two options here. One is we continue to litigate. I know, having been in private practice, that Jesse's firm probably would prefer that because that's revenue to them. But we can litigate in every state, in every locality, what the issues are, and maybe ultimately Cheryl will find a judge that doesn't view cable, the provider, as being that cable service that existed 40 years ago, that it's basically a communications pipeline company that is operating in our public streets and highways. But the other option is that we do these working groups. We work together, whether it's at the state level, at the national level, municipal level, it doesn't matter. Going back to my own personal experience, the companies that I represented when I was in private practice, particularly the attorneys in those tax departments, were some of the smartest people I've ever dealt with in my professional career. They know what the strengths of their positions are. They also know what the weaknesses of their position are. And I think it's time we look for the long term, because, like I said in my intro earlier in my intro, what we have now is an equitable, sustainable, or competitively neutral. So with that, I yield, Drew.
Okay. Well, listen, thank you very much for giving us your thoughts on the matter. We want to hear from Jesse, and let's go ahead and turn it over to you to give us your thoughts. I understand we can't see you right now, but let's still turn it over to you for 5 minutes on some of your perspectives that you bring from your work on this issue, Jesse Ring at Amundsen.
For having me, Drew. I really appreciate it. And I apologize that my technology is not cooperating right now, but hopefully we'll get it up and running before the end of this session. So as you mentioned, I co-chair the Appellate and Supreme Court practice at Jenner and Block, and have had the pleasure and honor of representing NCTA, the Internet and Television Association, in a number of matters, including the one that that Cheryl and I got to argue back in March of 2020, just before the whole world shut down. The City of Eugene case, which involved the FCC's most recent order on franchise fees and the mixed use rule. And that order, as folks may know, is really part of an ongoing kind of conversation between the FCC and the Sixth Circuit that has taken place over the last 20 years about the legal framework that governs cable operators' use of the right-of-way. So, you know, as everyone knows, in order to operate, cable operators have to obtain a franchise to operate a cable system. But Congress placed important limits on what franchising authorities could demand for the use of the right-of-way. The limit set by federal law is 5% of the cable operator's gross revenues for the operation of the cable system to provide cable services. And so in its most recent order, the FCC said, set what actually counts toward that 5% cap, and that does include in-kind services as well as cable-related in-kind services. And the Sixth Circuit also, or the FCC also established in that last order the mixed use rule. Congress knew that cable systems could be used to offer more than just cable services. Congress knew that cable systems would be used to offer information services like broadband, but Congress expressly limited the franchise fee to 5% of revenues from the use of the cable system to provide cable services. And so what was really at issue in that Sixth Circuit case were the additional franchise fees that some local franchising authorities were imposing on cable operators' broadband revenues. And so what the Sixth Circuit said was, you really can't do that. Because franchising authorities are prohibited from establishing requirements with respect to information services, the Sixth Circuit said that local franchising authorities can't use their sort of police powers to do indirectly what they are prohibited to do from doing directly. So the court kind of specifically held and applied that reasoning to the 7% fee that the city of Eugene was attempting to impose on a cable operator's broadband revenues. And so I think it's important to sort of look at the Sixth Circuit's reasoning and what it held, which was that the power of a franchisor is the power to grant or to deny access to the public rights of way to construct and operate a cable system. But when the franchise is granted, that gives the cable operator the right to use its cable system, including, as Congress anticipated, the right to use the cable system to provide information services like broadband. And so what the court said was, once that franchising authority grants the cable franchise, it surrenders its right to exclude the cable operator from the rights of way, and it cannot then impose a new license fee on the same cable operator to use the same cable system in the same rights of way. And so I think it's important also to note that while the Sixth Circuit's decision came out prior to the Supreme Court recently overruling its Chevron doctrine in the Loper-Bright decision this past year, the Sixth Circuit did make that ruling based on the plain text of the statute and without any sort of deference to the commission. So really the established law is that the best reading of the statute is that franchising authorities are precluded from requiring cable operators to pay twice for access to the same rights of way.
Excellent. Is that your final thought? I didn't want to cut you off.
Thanks. And apologies again that you can't.
No, this is great. Thank you so much.
You can just imagine that the mouth is moving in the picture that you're looking at.
Well, once again, this is really a rich discussion. I'm glad we're able to get each of the three of you that we do have on here. So I guess the first question that occurs to me is like, in some ways, this is the issue that cries out for a rewrite of the Communications Act, because, again, I think Cheryl's made some very good common sense points. Bert, likewise, and Jesse too, right? I mean, like, you can't force someone to pay something that they're not required to pay under the clear language of the law, and yet clearly it does seem odd that traditional cable video services would be subject to a fee where broadband and what used to be called over-the-top streaming are not subject to it. So let's actually just go in the same order we went in. I mean, like, is this something that can be reconciled short of a rewrite of the Communications Act? And what are the kind of narrowing principles, Cheryl, that you would impose by saying, hey, this is how the FCC should justly accord fees on others besides the traditional cable revenues in play?
Sure. Well, I think the biggest issue that I want to take with Jesse's point is the idea that cable operators are paying twice. Because keep in mind that what we have is operators paying a percent of revenue. So most of the major cable operators also now provide internet. If you're Comcast or your Charter, you provide both an internet product and a cable product. And as we all know, traditional cable, as Bert said, the inaptly named cord cutters, traditional cable subscribers are going down, and broadband subscribers are going up and up, and the revenue from those services and products are going up and up. So no cable operator is paying twice. They're now, what they're paying is 5%, say, for example, of revenue that is going down, and nothing on the revenue that is going up and up. So eventually, if cable continues on the current trend line, you're going to have a company in the right of way that is paying nothing, because the old traditional service is no longer being assessed, and the new service that they're providing over the same essentially the same plant is now being offered free of charge. Meanwhile, if you are a company that competes with a cable operator, but you just provide broadband, you don't provide any traditional cable service, and you don't have a cable franchise, you probably have a different agreement with the local government to be in that right of way. Local government can do whatever they can definitely charge you a fee based on your broadband revenue. So I don't see why a cable operator should be free. It's not paying twice, it's just paying once based on the system. So, and we obviously disagreed strongly. I think the FCC, there's still, I think, some room for interpretation and implementation at the FCC, and we certainly have had that bit of a debate at the FCC with respect to the continued vitality of the mixed use rule. We actually think that the Sixth Circuit was pretty negative about the mixed use rule, and said the FCC didn't really capture the law in that rule. So I think we do have some things that are coming down the pike with regard to that, but I do want to be really clear that there's in no way is anyone saying that cable operators should pay twice.
Bert, and then Jesse. I definitely want Jesse's response on that.
Okay. I don't want to pick on Jesse, but I want to go back to the start of the 1984 Cable Act. One of the key reasons that law got passed was because of Congressman John Dingell from Michigan getting his major issue with the law, and that is that the FCC would stay out of franchise fee disputes, because pre-Cable Act, all the franchise fee disputes came to the FCC. I know because Connecticut Cable Association at the time brought one of the leading pre-84 Cable Act cases to the FCC. We kicked that around at the DC Circuit for a while after the Cable Act, and ultimately that was resolved. In Connecticut, cable is taxed and regulated at the state level. The reason it is taxed and regulated, it was set up by our local phone company, which was an independent, it was not a Bell operating company, but they wanted to make sure that cable had the same status as they did. So the answer, in my perspective, does not lie on taxing individual program services that offer their services over the internet. I'm not going to be, I think the Netflix, Hulu, YouTube TV, I think that becomes a distraction from the main issue, which goes to the core of the way that you started the conversation about the rights of way. And I think that we have to look at what's happening on the rights of way. I live in a fairly rural area in Connecticut. In the communication space on the pole, there's two companies. They each have two wires. One is fiber, one is non-fiber. One is the cable company, one is the telephone company. If you get your service through the non-fiber line, the company passes on to you a 5% gross earnings tax plus a PEG fee and a regulatory fee. If you get the same service on the fiber line from that company, those are typically not added to the bill. It's the same service.
So
Functionally, it's just a different
So, yeah.
transmission technology.
So
I know they can move on.
thanks for those points. Jesse, I want to definitely get your response to these.
Sure. So I think that the issue is what the law requires. And so what might be good policy or what might be sort of advocated for to Congress is one thing, but what the statute actually requires is simply the franchise fee cap is 5% of revenues for the provision of cable services. And so what the FCC held and what the Sixth Circuit then upheld was that franchising authorities can't be sort of demanding additional fees on top of that. And so I think the kind of just overall bargain is once the cable operator has access to the rights of way to operate a cable system, which includes the provision of information services, telecommunication services, the cable operator only has to pay that one fee for that access. And so, again, while there may be policy reasons for a different regime, that is the regime that is in place right now and that the Sixth Circuit has upheld.
So we clearly have two parallel conversations going on, like what the tax system we should have and what the tax system we do have, right? And I recognize that panelists can answer on either level, right? What it should be, what it is. But let's just take an example. I understand the city of Chicago has an entertainment tax, and that actually has been held or it hasn't been not held to encompass things like video streaming services. So are there other ways to slice the apple that could get at and not disproportionately tax similar services? And for example, with the entertainment tax that Chicago has. Let's just go in the same order we've been going in. Cheryl.
I think the Chicago option is definitely a viable option and does circumvent some of this debate. But I think that every community and every local policy makers want to make their own decisions. They want to tailor the importance of how they collect revenue, how do they meet the needs of their community. They use their own power and their own authority and their own feedback from their own voters to determine how they make these policies. So I think that the Chicago model is excellent, but then that might not be the right model for every single community. And I think the important problem that we have with the current interpretation of the law is that it's really the FCC is running roughshod over that independent police power that all local governments have, is to make these determinations. So the local government may not have the authority under the Cable Act to do anything with regard to a broadband provider, because of course the Cable Act doesn't reach a broadband provider. However, the local community certainly has the authority to impose a fee on a broadband only provider because they have that inherent local authority. And that really depends on their local and state law, right? Many states have decided they don't want their local communities doing that. And so those local policymakers, those state policymakers have made that decision. So it's definitely one of those things where we have the beauty of federalism, where each local community and each state determines what kind of policies they want to have, what's going to best serve their economic and social climate in their area. But what we have is the FCC sort of putting their finger on the scale at one discrete point that tips everything sideways, and then doesn't permit logical decision making at a local level where you could adopt a more even-handed, equitable solution, because the FCC is only putting its finger on the scale in one place and in behalf of one portion of the industry sector, and that just isn't fair.
Bert, maybe you could also speak to the state versus city issue and how a state like Connecticut factors through the question of the city authority versus the state authority.
Sure. I think at the state level, Drew, states have much more latitude. So for instance, the definition of franchise fee also has things that are not franchise fee, taxes on other entities. It uses the term utilities, but I would say at that time in 1984, when that was written, telephone, it wasn't even called telecommunications back then. Telephone was a utility. So to me, the best answer is at the state level to put a equitable, non-discriminatory, competitively neutral tax on all providers of communication services, irrespective of what that service is. You're in the public rights of way. You have facilities. It's essentially fair and reasonable compensation, whatever that is. I'm a lawyer. I'm not an accountant or a financial tax person, but I know that that is allowed both under the Cable Act and under the Telecom Act. And so with that, I mean, that's the best I can come up with for you, Drew, but I think it's a viable way of dealing with it. And to be honest with you, I have trouble as someone who's litigated and done a lot of litigation with, I just have trouble thinking of a judge who would find that to be discriminatory, to find that violative of the Cable Act.
Jesse, just returning to you and the entertainment tax approach, as well as, of course, as like maybe a difference between facilities or non-facilities. Is there a rational reason for such difference in tax treatment?
Sure. So I think the entertainment tax is kind of an example of a way that cities are attempting to get around the fact that the law says that cable operators only have to pay once and pay only on their cable revenues for access to the rights of way. So this is a way of sort of trying to circumvent that this is not a tax on the access to the right of way. And then I guess I would just, respond to kind of Cheryl's suggestion that the FCC is sort of putting the thumb on the scale for one side of industry, to say that, what the FCC did was interpret the statute, and what the Court of Appeals then did was uphold the FCC's interpretation of the statute, not with any deference to the FCC, not saying like, we don't really agree with the FCC, but we nonetheless are required to defer to them as the agency that implements the statute, but instead actually agreeing that this was in fact the best reading of the statute, and that localities are precluded from adding additional sort of fees for broadband services on cable operators who've already paid for their access to the rights of way.
Let's take a hypothetical world where we don't have the current structure of the Communications Act, and we're trying to decide what is an appropriate vehicle for taxation. Is it the use of the facilities, i.e. the wire to the home or business, or is it the service that rides upon those wires? And bonus question, what do you do with wireless in that case? Okay, so let's just get it out there. What do you think is the right way, right, quote unquote, to and put on our platonic guardian hats here? What is the right way to design a regulatory system so that it is, fair to different types of services, but not, allowing regulatory arbitrage? I'm going to start with Jesse for this one, okay?
Well, Drew, I'm actually mostly going to duck your question as someone who is a litigator who deals with the law as it exists, as opposed to trying to design the law as it might be. But, certainly, I guess I would just step back and say, like, we've been talking a lot about these fees and what it means for cities to be able to charge them, and the revenue that might be lost to cities as a result of not being able to charge them. And in fact, I think it's just important to remember that these are fees that get passed through to the consumers. So I think as we consider whatever system might be designed, that's kind of the most important thing to remember as well.
Well, and again, we all understand we come from our particular corners and approaches, but I can't resist asking, with the FCC's reclassification of broadband to become a telecommunications service, can I just get an answer on how that does or might impact this taxation framework that we've been speaking about thus far? And again, Jesse first, and we'll hear from the others too.
Well, I think, as you know, that reclassification is currently on hold with also the Sixth Circuit, with a panel that's very similar to the panel that decided this most recent case. So, I don't really see how that. I guess I don't want to hypothesize on what might happen in the event that actually goes into effect. But for now, I think that the Sixth Circuit has been pretty clear that it may well not go into effect given their granting of the stay.
Bert and Cheryl, let's kind of get your take on this too.
Cheryl, I'll let Cheryl go first.
Oh, okay. I was going to go last. Okay. Yeah, I mean, I think in some ways I'm similar to Jesse in that I think, there's a lot of work for policymakers to do. And a lot of my job is to make sure that local decision makers and policymakers can be accountable to their own home communities. I mean, I did want to flag, I think Florida has a more unique, unified system that they call, rather than a fee, they call it a tax, and it applies across the board and then filters back to local communities. Maine, as a state, just passed a law in the last year about treating video service providers more equally. And so that was another approach, kind of takes a different set of players and puts them into the base. So, but I think each locality in each state is going to have to think about what is appropriate for them. And then similarly, how does that fit into the federal scheme? I think, saying wireless doesn't have infrastructure, I think it's wrong, right? Like, obviously wireless has infrastructure. And if your concern is having infrastructure providers contribute in a unique way, then you would want to figure out how they participate, or you can go based on the content providers as well. And I think that's really what you're seeing, for example, at the federal level now with regard to the debate, that Brendan Carr and others have been saying, like, who else should be paying into the federal universal service fund. It's, in that case, you would have to assess those different bases differently in order to come up with a fair contribution overall. So I would go back to, obviously you want to have the least amount of burden on consumers. You don't want to be shifting the marketplace. You want the marketplace to operate as even-handedly as possible. And I think that's where, my client's position has been, like, let's be as even-handed as possible and the minimum impact as possible. But we can't forget that these local consumers, the taxpayers are the complete base, right? So the rate payers or the subscribers are paying a fee. They've chosen to subscribe to a service. But we have the ratepayers, we have the taxpayers who are responsible for all that infrastructure. So, you wouldn't let a car dealer suddenly put all their cars on a municipal parking lot to sell cars and not expect that somehow the taxpayers are going to get reimbursed for that, right? You don't let somebody just put their business in the middle of the sidewalk and use it just for private purposes. But there is a process by which private entities could use it, but the taxpayer needs to be compensated. So I don't want to forget that, like, the taxpayers are actually at the bottom, at the end of the row. And so we need local, and obviously local policymakers are very concerned to make sure that their tax base and their voters are being treated fairly, and that they're getting a good return on their dollar, that they're paying their taxes and they're getting a vibrant community with strong local infrastructure.
You're mentioning of Commissioner Brendan Carr's suggestion to, tax big tech as a way of kind of broadening the base of the Universal Service Fund, kind of raises this question of, are we really going after services that use the right of way, or are we going after services that are riding on top of facilities that use the right of way, whether that right of way is wireless or fiber? And thanks for that clarification, Cheryl. So is it logical to say, let's tax or put a fee on the facilities that use the right of way? Or are you saying, no, it's actually the services that we want to get at as well? Or are you saying it doesn't matter? We just need to kind of design a system that gets taxes to the appropriate entity?
Generally speaking, I think it doesn't. You need to have the system be fair, equal, the least burden, the least drag on the marketplace, and also produce the common benefits that are needed. And I don't, I think at one time it did make sense to just have infrastructure, contributors participate. But like just the debates that we're having right now, Chicago is taxing a service, but other providers, the city of Eugene was trying to really focus on the right of way in their case. So I think that's where you want local policymakers to develop a system that makes sense. I know Bert maybe has some thought about that in terms of tax policy. I don't know, Bert, if you want to say something about that.
Well, I also want to ask a question that's been asked of you, Bert, which is making a case for working groups to some new status quo. Does the cable industry, in your view, see any need to have such discussions? Let's let you answer first, Bert, and then we'll broaden out to this question of how we get more discussions about the appropriate tax policy here.
Sure, I do know because I have represented cable operators or associations on various tax working groups. But again, you need to have an understanding before you start there, either a new statute or basically a collaborative understanding of what, that there is going to be compromise on both sides. I'm not sure we're there yet. Real quickly, though, I 2 points. Number one, Jesse raised a good point about that, of course, our office, being the Office of Consumer Counsel, is very concerned about, and that is the impact on consumers. That happens quite frequently in utility rate cases, and it happens. It's part of the discussion here. But right now, what we have is a system that is imposed where the remaining cable customers, and it doesn't take, like I said, a great leap of faith or logic to know who those people are paying for public access. They're paying for the franchise fee or the tax. And so that is not right, just that segment based on what is Drew, you said at the beginning, what the transmission technology is. Because right now, the companies are migrating their channel lineups over into internet protocol if they haven't already done so. And so it's already being offered over the internet. And many of them are using that as an excuse to no longer pay their franchise fee or their taxes, depending upon the jurisdiction. Finally, and again, this is my personal opinion, I believe that there can be a resolution based on the existing law, and that is the exemptions for the franchise fee that are in the Cable Act would provide for a general, non-discriminatory tax on all providers of communication services in the public rights of way, regardless of how they got onto the public rights of way. And secondly, that fits right into the Telecom Act, which also allows state and local governments to require fair and reasonable compensation on a competitively neutral and non-discriminatory basis. We have the language in place. We just need the will and the resolution to do that. One final point. Right now, I know Jessie has been very careful. She's a very astute lawyer. She keeps talking about cable service, cable operators. These are no longer, the cable operators are no longer marketing cable service, Drew. They are marketing internet service. We have some overbuild situations in Connecticut now, and when the cable company enters the market and turns on the switch and lets everybody know, they'll take a full page ad out in the local newspaper saying internet, broadband, speed. There is not one word in that ad, full page ad about video or cable service.
Let's see if Jesse wants to respond to that, and then I want to get into at least one or two more quick questions for a panel. Do you want to say anything, Jesse, on that?
I mean, I just would reiterate that we exist in a world in which the law is as it is, and what the law says is that the access to the rights of way is given for franchise fee of no more than 5% of the cable operator's revenues for providing cable services. And so, I think that's the law as it exists.
There's a question that Walter Seambob has asked about possible to dedicate tax revenue to public interest purposes. And Walter raises digital equity being starved for investment. Now, obviously, this raises the whole question of public educational and governmental channels, which are kind of an additional requirement, at least traditionally, of cable franchises. Cheryl, do you want to take first this question of what's the appropriate way to make sure there is some public purpose in addition to the tax or fee of these services?
Well, certainly the Cable Act, the 84 Cable Act put a high primacy, and then the 92 amendments put a very high primacy on serving the local needs of communities. And the franchise agreements between local communities and cable operators provide for the resources necessary to create these public educational and governmental channels. Some people might think of them as cable access or public access, but that is a place in your community where you can create content, learn how to create content, and disseminate it to the whole community, and actually became very relevant and even more important again during the pandemic, because all of a sudden we needed ways to transmit more information broadly to everyone, regardless of whether they had necessarily broadband, and also became very important because it's a great opportunity for open government. You can't hold your local decision makers accountable if you can't see what they're doing, and they're often on those public access channels. So that is part of the overall deal that was struck in the 84 Cable Act. I do want to mention that although Jesse's very focused on what the most recent interpretation of the FCC is about this law and the Sixth Circuit, which I think there are some more gaps into that I'm not going to get into right here, but for more than 30 years, this interpretation did not hold sway. Has never been the interpretation. This came out of nowhere. If we'd had the major questions doctrine at that point, I think it would have been a primary case for saying that this is a major questions doctrine for like some crazy interpretation coming out of nowhere, making no sense and making bad policy. Unfortunately, Jessie can't defend the policy. She can only say that maybe the law says that. Well, the law says something ridiculous, and that was never said for decades before. So I think it's a good indication. But I think that it's correct that you want local communities to be able to decide how they're going to make these public information needs meet them. And one of them is through this list of discussion. But as we know now, some local communities have 5 channels and they have active educational channels, and some they have more active public channels. So I think, once again, I'm still going to come down on the side of flexibility for local communities to make sure that the needs of their community are being met.
Bert or Jesse, do you want to add anything to the public educational governmental question?
Jesse, is it okay if I go?
Sure, go ahead.
Yeah. To me, the issue of public educational governmental access relevancy is, again, it's a sideshow. It's a way to take the bullseye off the real issue of tax equity. Public access, at least where it's supported by the local cable companies, it's basically, and I'm kind of taking a page out of Jesse's book. It's part of the Cable Act. It's part of the obligation of these companies, and they should be stepping up and making sure that PEG Access Studios are fully funded, regardless of what the franchise fee is. That was their commitment. That is what they owe their communities that are supporting them through their monthly bills.
All right. We're going to give everyone a quick final statements, but anything on PEG that you want to add here, Jesse?
Yeah, just quickly, I think that what Cheryl said about flexibility for the franchising authorities, the Cable Act does provide such flexibility. And in fact, with the most recent interpretation from the FCC and upheld by the Sixth Circuit, the franchising authority now does have to choose how important public educational and governmental channels are to them, because the services that a cable operator provides for PEG, the operating costs, do count toward the local franchising authority's 5% cap only the capital costs are actually excluded from that. So I think that, in fact, the most recent interpretation from the statute from the Sixth Circuit does further sort of the flexibility that local franchising authorities have to decide how important these services are to them.
Well, again, the hour has sped by. There's so many questions we haven't been able to address. I'm going to give each of our panelists, in the same order we started, the same opportunity to close out the issue. But I will just sort of tee up any one issue I'd love your thoughts on, if you can slip it in, is the role of states streamlining, quote unquote, the process for cable franchise agreements. And has that had a kind of a good effect or an ill effect on this debate? I mean, clearly what we've seen is we've got a very complicated legal and practical reality, and there's questions about how the taxes or fees are imposed upon services in the right of way or services that are based upon facilities in the right of way. And we're not going to resolve all these questions, but let's just hear final thoughts from each of our panelists on this question of taxes and fees for cable and for video and broadband services. Go ahead, Cheryl.
Sure. I mean, I think unfortunately, many of the state laws that have been passed were not about streamlining, and they were more about, once again, just deregulating and removing some of the local opportunities. I think it's had a very detrimental impact on the public channel access system, because it really just starved communities for revenue in many cases, and certainly took the decision making out of the local arena and into the state arena. Certainly those are state policymakers' choices, but I think that's what we saw. I think big picture, once again, I'm just going to start with local decision makers want nothing more than to have as many companies as possible offering as many innovative products as possible, and also make sure that they fulfill their obligation as the steward of the public trust of the local right of way of local tax revenues. And we need federal policies that are going to empower and make sure that those local decisions, which were really some of the original obligations given to local communities to make sure that every house passed by cable, turned out to have incredible benefit to us today, because now that infrastructure is providing broadband to the degree everybody who has broadband. It was those local communities that put it in place. So we have to trust our local decision makers, and we have to create federal policies that are going to allow them to be even-handed and fair at the local level, at the state level, and at the federal level, and look at how all the different piece parts play together, how the universal service plays together with the local franchising process, with the other obligations that local governments have with regard to managing rights of way and the local public trust.
Thank you, Cheryl. Bert, we'll give you a quick moment to offer your final thoughts.
Okay. I think that the current statutory authority exists for at least state governments to implement legislation to tax all communication services providers that have facilities in the public rights of way, fair and reasonable compensation on a competitively neutral and non-discriminatory basis. That would not violate the Federal Cable Act if it applies to all communication service providers, because the Federal Cable Act specifically has exemptions about taxes of general applicability, which that would be.
And let's finally hear our closing thoughts from Jesse Amundsen.
Thanks, Drew. I think that regardless of whether the franchising authority is done at the state level or at the local level, the same limits apply. And the most important thing that the Sixth Circuit said in the last decision as to those limits are that the state or the local franchising authority can't use its police powers to do indirectly what it is prohibited from doing directly. And so if a local franchising authority is prohibited, as it is, or a state franchising authority is prohibited from imposing additional taxes, additional fees on access to the same right of way by the same cable operator for provision of the same cable services, it cannot do that through a means other than its franchising authority.
Well, that will have to be our final word. It's been a great discussion. Don't miss our next Broadband Breakfast Live online, talking about BEAD and satellite broadband. And of course, please check out the Broadband Breakfast events tab for information about broadband in the next administration on Thursday, December 12th. On behalf of our panelists, Cheryl Lianza, Bert Cohen, and Jesse Amundson, I'm Drew Clark, and I'll see you next week. Take care, everyone.
Thanks for having us.
Thank you.